In the following presentation, Rustin Diehl breaks down some of the things you need to know about protecting your digital assets in a trust. And if you'd like to set up a time to talk with Rustin, please email us at info@digitalfamilyoffice.io.
So my background, I deal in a lot of private wealth with mostly closely held businesses of different types. It's kind of like a house. It's probably more like a house than anything. To find a package deal is very difficult that meets your needs. And so to kind of look at it from that perspective, if somebody just says, what do I need to do to get a trust? That's kind of like walking up to a builder and asking, what do I need to do to get a house? They're going to have a lot of questions to follow on to your first question. So these kinds of instruments are designed primarily for three purposes. Number one, for estate planning, to make sure that there is an orderly devise to your heirs and beneficiaries if you pass away, to make sure that we've got a clear plan for that. Number two purpose would be to protect assets. In some cases, we set up trusts that can protect assets. There are some trade-offs in doing that. And so I'll again and again mention to you, there are always trade-offs in the different kinds of trusts in terms of asset protection. And the main trade-off is between flexibility and control. Those are the big trade-offs. If you give up some control, you get more asset protection and you're less flexible. If you want to maintain control and flexibility, then you have less asset protection. The third reason to do trusts is generally for tax planning, and there are several types of taxes. So there are transfer taxes. That's taxes on appreciation of assets. So if you have an asset that's appreciating, getting it out of your estate can be very helpful on the transfer taxes. Those are primarily taxes on gifts during your life and taxes on transfers, estate taxes after your death. And the second type of taxes we can plan for in some instances are income taxes, taxes in the category of capital gains and investment income and earned income. So those three things, estate planning, asset protection planning, and tax planning, are the main purposes of these trusts. And there are a great number of trusts of various types that you can set up for these. Now, sometimes you'll get kind of fixated on a specific type of trust, just like somebody might get fixated on a specific vehicle, and all they know is the vehicle make and model and all the specifics on that, and they'll come to me and say, I think I want this vehicle, and they might need a minivan, but they're looking at a Porsche. And so I see that quite often. So you can break down these different types of trusts because there are infinite varieties. And in fact, many of the trusts that people come to me with are similar to like a Porsche, a G3R or something like that. They are a very specific model that another attorney, in fact, has taken general characteristics like a chassis, a motor, the cabin and the seat belts and the airbags, and they've packaged them together like the Porsche, and they have decided that they want to brand them. And so they'll even trademark the name, even though the concepts underlying the trusts are general. Anybody can set up that trust. Some attorney will trademark the name. So just be aware there are thousands of names for different types of trusts that marketers come up with the name and then trademark them, and the attorneys sell them. So what you need more than anything, rather than picking a specific vehicle, is you need a skills-based attorney who has a background in estate planning, in asset protection planning, and tax planning. And so you're welcome to look me up on LinkedIn, but I work in all those areas, and I've done a bunch of work for different families across the country in those areas. And so I'm able to set up trusts that are specific to you, just like you'd want your home to be specific to house you. You want your trust to be specific to house what your needs are. So that's a basic overview on what I do. I have a general Swiss Army knife set of skills in this area, and the trusts that I develop, I don't trademark all my names. I come up with exactly what somebody needs in terms of estate planning, asset protection planning, and tax planning. The best way to describe the pricing is based on my hourly rate. And so to give you an idea, I have a Juris Doctor and an LLM in taxation, which is a postdoctor in taxation from Georgetown. And across the country, comparable skill sets, you can find an attorney with a hourly rate of triple mine or quadruple mine on one of the coasts, especially the East Coast. I'm basically in the Mountain West, and so my pricing is different than those coastal markets. But that's probably the best way to describe it. Most trusts that I set up at the low end require approximately 10 or 12 hours multiplied by that hourly rate. If I do multiple trusts, several trusts for a client, then that can multiply by the number of different trusts, because we might need to do one trust for assets that are going to get traded around and exchanged. Might need to do a different trust for assets that are going to be protected and held. Might need to do yet another trust for assets that are going to be positioned in a jurisdiction, for example, for digital assets that deals better with digital assets. So depending on the size of an estate, we might have anywhere from one at the low end, and I've got clients with 8 or 10 trusts at the high end. We don't try to overcomplicate these things, but each one of these vehicles deals with a different thing. And so you can imagine, just like a family might have one vehicle, one car at the low end to deal with all their needs, and then I've got clients with 40 different cars to drive around in for different purposes. So it just depends on the person. But yeah, everything's based on my hourly rate. And then I do set a fee for the different types of trusts, a fixed fee depending on the characteristics. So yeah, the range is, depends on how many trusts you need. But the range is usually between, at the low end, around 10 hours for a very simple trust. Some trusts I do are over 20 hours of time. I'll walk you through a couple hypotheticals. That's probably the best way, is to just start exampling how a trust might work. So kind of just to lay out a fairly typical hypothetical. If you got a married couple, and let's just say that right now they own a house that they're living in, and then over the years they may have bought a couple of rental properties. Maybe they lived in the houses over time, and so got a couple of rental properties. They've got their house, their residence. Let's call that the home. And let's say that they've got a 401k, maybe two of them, and maybe a 401k and an IRA. The 401k, they've got 500. In the IRA, they've got 200. And then in addition to that, let's just say that they have some digital assets, since we are on kind of a forum for digital assets. There we go. So they've got XRP, and they can have, whether it's in cold storage or on an exchange, there's different ways of dealing with this. Now, XRP, I'm just going to make a big disclaimer. I have no idea what's going to happen to it. That's for you guys. I don't want to get in on the hype on any asset, because I've never been right, and I don't know what's going to go up and what's going to go down. But who knows? A lot of people think that XRP could go up or down. And so given that we're talking about the potentialities of this asset, that is a unique thing to think about. We don't know what way it's going to go, so we have to build trusts that work for that volatility, for that both systemic and non-systemic risks of XRP and any other digital assets. These are a nascent and developing market, and so I tend to build trusts a little differently for assets like this that have great potentiality to either depreciate or appreciate. Okay, so let's talk about the three things that we ought to think about in digital assets. As far as estate administration, whether or not this goes up in value, there's some complexities in dealing with digital assets in an estate. And that could be an entirely different presentation. I've given that presentation numerous times, but planning for digital assets has its own unique issues in estate administration. Just the institutional costs and challenges of managing those in an estate are in and of itself one reason to look at these separate from the others. Another reason would be to look at these as asset protection. I don't know what these guys do for work yet, but if they're professionals, either in dealing with investments, maybe one of them's in real estate, one of them could be a doctor, insurance sales, finance, all those things. If they're a professional, then they have their own unique risk. Let's just say that this person in the couple, this spouse, has got a risk because of the way that they work, what they do for a job. And then they've got these two risks. Rentals are hot items. And I would imagine all of us are going to drive around a little bit today in our cars, and we're probably not going to see any car wrecks as we drive around. Yet we all know full well that there are car wrecks happening all around us every day. Renting it out and have all these renters in there does not mean that there aren't rental accidents happening all over the place. You just haven't had one yet, but they can be quite big when they do happen. And so you've got these 3 risk points. And so asset protection is a good idea for this couple. The other reason would be tax planning. Tax planning for these, as I said, could go both ways. We don't know if this is going to go up or down. And so we want flexibility that if it goes up or down, we can deal with it inside of this trust. Now, that's a challenge, as I said, to try to meet this trifecta of needs, to have tax planning, asset protection planning, and estate administration. And so I can't really put out a package deal because it's always unique to the person what they're going to need. So let me kind of illustrate this. Let's say that what we do on this, a very good way to deal with these is to put in place a trust. And often what I'll do is put in place a Wyoming Domestic Asset Protection Trust. Why did I choose Wyoming? Because they have got the foremost in estate administration features in their statutes. The jurisprudence in Wyoming is very much in favor of digital assets. They've got they're the leader in all of the digital assets law. They put in place the first DAO. So if we had, in addition to XRP, let's say that this person also had minted a few NFTs, we might put the NFTs in a DAO LLC. A Wyoming DAO LLC is a very good holding structure for any assets that a person has minted for which they might retain risks of different types. And you can see in the bulletins I'm getting, the SEC is starting to crack down on NFTs as being securities issuance. We've got to be very careful about that. There's a lot of different areas where these assets are now being retroactively regulated. And so I have set up a number of DAO LLCs for very specific assets that can go inside of a Wyoming Asset Protection Trust. Wyoming Asset Protection Trusts are excellent for both estate administration, but they're also very good for asset protection. Wyoming's law provides that after you've put your assets in here, as long as you are very careful of the transfer, another risk point is the transfer in. You can't be transferring assets into this trust unless you're going to do it and not leave yourself broke. You can't put your assets in here to hinder, delay, or defraud your creditors. You cannot do it in the face of threatened or pending litigation. You've got to transfer in and leave yourself liquid. So you have to sign an affidavit of solvency in order to do this. And so that's part of the work involved in these trusts, is making sure on the solvency side that somebody transferring into, say, this Wyoming Domestic Asset Protection Trust is still solvent. So we've got to leave the person solvent in putting the assets into this trust. Now, once they've been in there and we've waited under your local law for transfers, most of the time that's a couple of years, 2 to 4 years, these assets are under Wyoming law are protected from creditors. And so it provides that if something happened on one of these diverse risk points, either up here with this profession that could go wrong, or here with the rental properties, people cannot get in after the property that you don't own. And that's a fundamental characteristic of asset protection planning. Let's just say, just as a hypothetical, that this person had already put their rentals into LLCs. Okay, they had rental LLCs. So you might be wondering on the asset protection point, why would I need a trust when I've already put my rentals into LLCs? Okay, so the answer is the LLC protects you from your renter. If that renter has a blow up, has a problem and tries to get out, as long as that LLC has been adequately capitalized, they cannot pierce it and get out. They're stuck in here. They can't get out and try to get after these. They can't sneak around and try to go upstream. However, if something goes wrong up here, They can go straight downstream and grab either of these. That's the problem. They can go downstream. We have a liability problem. Downstream is still possible, and that is why often we'll do even a separate trust specific to the rentals. Now, if this couple splits up, we have to be aware that marital protection is not afforded unless both couples sign off on these trusts, because divorce courts are courts of equity, meaning the judge gets to do what they think is right. And so they can set aside a lot of different plans unless we're very careful on the way in. But to protect from downstream liability, let's just say this person malpractices in their real estate career and their errors and omissions insurance is not enough. Somebody could go downstream unless if they're going after property that this person doesn't own. You can't be sued for what you don't own. And so for downstream risk, that is why we set up these trusts, even if you have LLCs. Just to reiterate the example, this guy malpractices. He does a real estate transaction badly or sells insurance wrong and gets sued by the client. And the client says, turn over everything you own. And he says, well, I've got malpractice insurance. The client says, that's great. Give me the whatever, 2 million, but my damages are 5 million. Now, where are you going to cough up the other 3 million you owe me beyond your insurance? And he's going to say, well, I've put everything in LLCs. I've got my rentals in LLCs. And that client that he messed up the real estate deal for is going to say, great, thanks for putting your rentals into LLCs. Now give me your LLCs because you own them. Unless they've put them into a rental asset protection trust, those are at risk from downstream. So the rental LLC protects them from downstream risks, whether it be the asset protection that's afforded for the digital assets or the rentals. They do have to give up something. They're going to have to give up something to make it work. So with both of these trusts, in order to have the effective protection, we've got to have a distribution trustee that's a bit of a buffer. Now, if we're talking about a Wyoming trust, I have a distribution trustee. I've used several on a number of different cases for a lot of years. And in the last few years with XRP coming out, this trustee's got excellent both cold storage. So you can house cold storage with this trustee. And there's a specific way we do that by splitting your key into 2 pieces. Since these are cryptographic type assets, we split them cryptographically. So the key is split into a cipher, your key is split into a cipher and key. Kind of like old radio code where you have all the whatever 10-4, 10-20 means your location, 10-4 means everything's good, 10-10 means there's a problem. You got all these radio keys where somebody with the key or the cipher to those 10 codes on the federal radio stations can interpret what you're saying. You do the same thing with your cryptocurrency key. So we can split them and house them with your distribution trustee. But you have to have a distribution trustee in Wyoming. And before money can go out through the distribution trustee, they have to make sure that there are no creditors after it. Their role is to make sure there's no creditors. But you can't just pull the money out without going through the distribution trustee. And that applies to both of these trusts. That's how you get the afforded the protection, is you have to have an unrelated, unsubordinate distribution trustee over purse strings. Now, inside of the trust, to the extent that you want to, you can manage that. Now, there are trade-offs in managing your assets. The more control you have over them, the less asset protection is afforded. But in general, courts are willing to afford some control as long as you've got a distribution trustee not allowing you to distribute the money out without first going through the distribution trustee. And so inside of here, you can be the manager of your assets. You could sell this XRP and buy more real estate, but that real estate, if you were to liquidate, has got to stay inside of the trust. So you could buy real estate, but it's got to stay inside the trust. Yeah. So first step, you've got to have the vehicle that it's gonna ride in. The XRP's got to have a vehicle, so you've got to form the trust. Then after that, once we've got the trust form, we've got, and forming the trust is a big process. I'm skipping over a bunch of sub steps here. You've got to have a trustee appointed, a whole spreadsheet worth of check boxes to get this done right. A lot of compliance with state laws. So just know that's a big step that I'll asterisk. There's a lot of risk in that. And then you transfer into the trust. If you were talking about cold storage, then you'll do what I just described. You'll split your key into 2 pieces. You can keep half, and the trustee can keep half. You could transfer your entire key to the trustee and he keeps it in lock and safe. He's under a fiduciary duty. It's again, the trustee that I generally recommend in Wyoming is an attorney that I've worked with for more than a decade. This particular attorney, he does the similar area of practice to me, does a lot of private wealth. And so I work with a Wyoming trustee there, this attorney, and you would transfer either half of your key to them or the full key to them. Now, retaining half is obviously a protection, because in order to make the key work, you've got to have both pieces. There's, obviously, just like with any key, you've got to be cautious of the risks there. But the key is that once you've transferred the key or the cipher to the key, split it in half with a key and cipher. Once you've transferred that, that's why I mentioned like Federal Radio. They've got all the 10 codes. 10-4 means good. Well, you don't know that that means good unless you've got the cipher. If I just say to you 10-4 right now, and you don't have that cipher that you know that 10-4 equals good, you don't know what I've said. And so it's the same thing in transferring your key. So sometimes we'll do a key and cipher, just going back to cryptography. That was why I made that comment.
Mm-hmm.
So you need to transfer either one or the other to your trustee, and you can't retain the ability to transfer it yourself, or else you don't have an effective transfer of assets. And that starts to impact your taxes. But yeah, we need to split these into a key and cipher. That's the basic process. Now, once we've transferred, if the transfer is complete, we have some compliance, meaning, and this is where it gets a little more tax complicated, if you want to have the appreciation or locked out of your estate, if it does go up in value and you don't want to have an estate tax, then you do need to file a gift tax return afterwards to show that you've actually locked out the appreciation. File a 709, and that requires an appraisal on the assets. And the reason it requires an appraisal is because these are not considered securities in most instances by the IRS. And so they generally require that you get an appraisal on the assets, since we cannot mark them to market to set the price. Because if you transfer whatever $35,000, $40,000 worth of XRP right now, we need to file a 709 to show that's the amount you transferred, and then that goes against your lifetime exemption from gift and estate tax. But if we haven't done that, then this asset is still in your estate. And so if it suddenly had a jump in value, an appreciation event occurred, that appreciation event would all be inside of your estate, even in this trust, unless we have completed the transfer and filed this return. This is on the tax planning side. In order to have an effective transfer, we've got to do that. Now, in order for that to work, in order for it to be a completed transfer, there are some other things that have to be built in. So your beneficiaries on the trust really matter in this case, who it goes out to. If this plan, as the beneficiary, if you retain your beneficial interest on this plan, you were to retain that, hey, we are the beneficiaries, so this goes back to us, that can be a problem. And then also that's for if you retain the beneficiary, that can be an issue with tax planning. Also, if you retain the tax to pay the taxes, pay the income tax, that could be an issue later on. And so generally, I either make you a non-beneficiary, so you're not a beneficiary. Most people put their kids so that it will actually just go out to their kids. Most people set it so the kids are the beneficiary. But if you retain these two rights, that could make this moot. It could make your transfer incomplete, and so any appreciations in your name. Now, you'd probably want to wonder, why on earth would I want to pay the income taxes on this trust? Now, why would you want to do this? Well, the answer is trusts or either you or the trust will be paying income tax if there's income tax to be paid. You're going to be paying it, or the trust is going to be paying it. So why would you want to pay it rather than the trust? Well, if you're going to pay income tax, you have a lower tax rate than the trust effectively. because you get a standard deduction and the trust does not. The trust pays the highest marginal income tax rate at a much lower threshold than you do. And so one of the reasons that a lot of people prefer to pay the trust, the tax rather than the trust, is because it's often less taxes. And so they often retain what's called grantor status on the trust. They retain certain rights over the trust property so that they can pay the tax rather than the trust. And so this is always a question whether we're going to retain grantor status. And so I generally build in on these two areas is where I have to do a lot of customizations. Now, if you're not confused, you're probably misunderstanding something. This is like a foreign language. There is a lot of what some people call legalese, what I call clear communication. Legalese is just a simple way for attorneys that are initiated into this language to speak. And so as much as we'd like to get rid of it, we can't. It's like trying to get rid of medical talk. Medicalese is a way for physicians to quickly communicate important concepts so people don't die. Same thing with legalese. All these things, these complexities you're seeing, are there so that we can deal with a taxation system. So we all have a road to get to work on and all those things. Much as we don't want to pay them, we have to have clear lines, and nobody wants to pay taxes. And so there's a cops and robber game going on. So what you're seeing here is a multivariable calculus. In order to effectuate a plan, we've got to look at both, again, all these things. Estate administration, where's the best jurisdiction for these assets? We've got to look at the asset protection. How much asset protection do we need? And again, that's a factor of the risks of the assets the people own as well as the people themselves. And then we've got to look at tax planning. In the tax planning, do we think the asset's going to go up or down? And if we're going to do tax planning, if we complete the gift, in other words, if the people that make the trust don't retain beneficiary rights and maybe do or don't retain the ability to pay income taxes at the lower personal rate, that can change whether the gift is complete. So then what we're looking at is if the people decide, we want to keep this trust tax simple, don't want to complete the gift, then they're just really aiming to get these top two benefits. But in order to do the tax planning as well, we've got these additional big considerations. So that's kind of an overview on how this works. I realize that's a lot. And for anybody who's learned a foreign language later on in life, you just kind of have to work through it. It's difficult. And that's the challenge of dealing with this. It's not so much
I have a question.
It's foreign. Yes, William.
I see an opportunity here, but maybe you can provide some guidance. How would I, and this is kind of ancillary, but pardon me if I say I see dollar signs in front of my eyes. How could I become, because as far as I know, there's no such thing as a licensed digital asset appraiser. How do I become a licensed digital asset appraiser so I could get that job in the compliance area and seek an opportunity?
Yeah, so there are tests in order to be a qualified appraiser. You have to be a qualified appraiser, and you're correct. There could be a lot of market opportunity. I do have a valuation company that does deal in digital assets. But yeah, there are specific credentials that you need to pass a test. There's national tests in order to be considered a qualified appraiser, and the IRS sets those rules. But yeah, you have to have a qualified appraiser. That is a good question, and that is a market opportunity to be a qualified appraiser. Imagine, and just to kind of, it's a very interesting topic. How do you appraise NFTs? If we had a pocket of NFTs that we maybe put into an LLC up here, some NFTs that have been purchased or minted by this person, how do you get those appraised? And so that comes down to a qualified appraiser. Now, one other interesting thing about the appraisal of these assets that I'll mention, and this is kind of what I mentioned at the beginning. I said, when somebody asked me, how much does this cost? My answer was, well, how many square feet of house do you want? Basically, is how I answered you. How many rooms do you want in this house? Well, if we could add on another room, because I've done a lot of work in the wealth augmentation and regeneration space. And so once you have enough value, once this couple has enough net worth to where they're worth, let's say they're worth I don't know, with these rentals and everything, maybe they're worth $10 million and they've got a little bit of value here as well. Who knows if that'll go up or down. But once we've got enough net worth, just like you can take your credit score and generate wealth. I don't know if you guys have ever generated wealth with your credit score, but this is called credit score wealth right here, these rental properties. They were given the ability to borrow money from a bank because they were creditworthy. That's how they ended up with all this wealth, these rentals. And just like you can generate wealth on your credit score, you can also generate wealth on your insurable interest, on your insurable interest value. Everybody has a number over their head on how much insurance they can buy, but most people don't even make use of it. Just like most people don't use their credit to build wealth, most people don't use their insurable interest number to build wealth. But they have a value over their head, their mortality wealth value. And just like most people don't use their credit score, well, maybe they used their credit score here. And maybe they would also consider using their mortality value to create shadow wealth, because you can often, just like you can go to a bank and borrow money on your credit score, you can go to a bank and borrow money on your mortality wealth. And you can build another trust specific, and there's very specific features in here, but a mortality wealth trust. And we can use either insurance, modified endowment contracts, private placement life insurance. But a mortality wealth trust is another area. And that is where I've actually done the largest planning I've ever done has been in the space of mortality wealth, where I've done hundreds of millions of dollars. I've seen people triple their net worth using mortality wealth. And so I do set up a lot of trusts in this area as well. And those are, generally speaking, both for tax and asset protection. They're life insurance trusts. If you've ever heard of an ILA, irrevocable life insurance trust, those are the types I set up. But those types of trusts have a lot of feature for tax and asset protection, as well as estate planning. So I just mentioned that as an example of what we started with. How much does it cost? Well, I don't know. Do you want a chance to augment your wealth, maybe double or triple it? Because there is an extra trust that you'll need there, and that is a bunch of time. I've been hearing a lot of market hype about whole life policies lately because the equities markets are soft. I was hearing the same amount of hype about indexed universal life, IUL policies, about 5 years ago. I've been in the mortality wealth space a while, so I'd kind of back it up a step and kind of say that most often I recommend a blend of policies, because there's two ways that a mortality wealth trust can fail. And so I often, and in fact, I've even come up with and worked with some private placement life insurance groups to be able to fund trusts that are IULs, that are private placement, using digital assets or digital asset traded funds. You can actually fund those with certain, as long as we're diversified, there's diversification requirements. We can fund this trust with digital asset related equities. So that would not be a whole life policy, but I generally recommend that those be funded with a blend of different insurance policies, because the way that those trusts have to be set up to be safe is we've got to mind two issues. We've got to mind, number one, the cost of insurance, and number two, the return on the insurance, and number three, the borrowing, the interest rate risk. So the way that I generally set these up, I don't like to put all my eggs in one basket. And so the groups I work with in setting these up, I go through a matrix of around 30 different criterion in selecting very carefully insurers, not just based on their rating of their policies, but based on their reinsurance. You got to pop the hood on these companies and very carefully look at who's reinsuring them. And we've got to look at the various features, whether these policies are going to have cash value riders and have an increased cash value quicker. There are different ways that we want to address systematic risks and market volatility, stochastic volatility within the way we structure this. And so I work with very, very closely with several groups in order to structure these carefully. But to just throw in we're going to throw a whole life policy in there would be very simplistic. We've got to be very careful, because otherwise the funding, the way that we finance this, the interest on the credit chassis used to finance this, can eat up the value of the policies. If you have an insurance company that starts to jack up the cost of insurance right here, if they increase it, that ruins the deal. If you have a policy where a private equity group buys out an insurance company and starts not indexing everything, starts to not credit, if we don't have the crediting going on, that ruins the deal. If we have too much interest rate risk and not a good private banking relationship or relationships with different private banks, then the interest rate can ruin the deal. So there's all kinds of things to very carefully structure these. And I work with a number of professionals in doing this. My main role in these things is to deal with the tax and asset protection planning. So, because I would first mention that contract law trusts, people usually assert that there is constitutional protection for contracts. And so they're usually based on that idea and that you can contract for anything you want. The reality is we are all subject to the statutes, whether we want to pretend that we can form a private contract or not. We are ultimately subject to being hailed into court if we don't pay our taxes, or if we don't satisfy creditors or people we've wronged. They can hail us into court, and the courts are not going to care whether you've put in place a private contract and assert that there is constitutional protections again and again and again and again, and I could say again and again multiple times. Courts, when they bring people in who assert that there's constitutional protection over a contract without regard to the statutes, the courts set that aside. And if the person, like Wesley Snipes, if they say, well, I'm constitutionally protected, they'll just say contempt of court and throw you in jail. So no matter to draw a distinction, to say that you can do a trust divorced from the statutory regime it's subject to is not correct. All trusts are contracts. People market the idea that you can be devoid of governmental controls through contract trust, but that's a slick marketing thing that has no basis in reality. You will be subject to a court that will hold you in contempt if you're not compliant with the statutes. That's a false distinction. There is no such thing as a separate contract from a statute, and there is no such thing as a statutory trust that is not a contract. All of my trusts are contracts, but they are contracts that are not divorced from the reality of our subjugation to statutes and courts. These are marketers, again, just a contract trust, or sometimes they call them constitutional trusts. They prey on people's ideology, but that's divorced from reality. The reality is all trusts are contracts, and all contracts are subject to statute. So with IRAs and 401ks, I do set up a lot of trusts for them. I set up a lot of trusts in instances where, these are already, I'll mention already, that these already have some amount of asset protection and some amount of estate planning and a lot of tax planning built into them. So the instance where you would want to put these in a trust is if your state statute did not provide enough protection, or if the estate planning available through beneficiary designations was inadequate. Those situations generally occur when you've got a beneficiary who is not well equipped to receive those assets. So that's a very circumstance-specific trust. If I have a 401k, let's say it's more like $1 million or $2 million, or an IRA that's that big, and these people have a child who has special needs, leaving that IRA or 401k to your child as beneficiary can be very, very dangerous to them. It can disqualify that child from the benefits that they were using, Medicaid, SSI, all those things. It can disqualify them from their benefits. And being disqualified from those can be life and death. It can cause them to miss medications, miss doctor appointments. It's a problem. And so I generally set up trusts for IRAs and 401ks when there's a problem with a beneficiary. Under the new rules, the Secure Act, specifically for qualified designated beneficiaries, I set them up. A qualified designated beneficiary is somebody like I just described, who's too young to receive a 401k or IRA, or who's incapacitated. And with a qualified designated beneficiary, the trust enables you to protect the beneficiary from themselves or from disqualification, while at the same time funding certain needs. And so those come down to looking at your local administration of Medicaid, whether we've got there are some savings accounts that can be used in certain states. for particular purposes. But those trusts have to be specifically designed so that we have, if we're going to put them in a trust, it needs to be see-through. Under the IRS rules, a see-through trust is one in which we've designated the beneficiaries so that the trust can distribute based on the beneficiary's required minimum distribution schedule. But those trusts, like a 401k or an IRA, they can stretch out the payments to any beneficiary for 10 years. For a qualified eligible beneficiary, it can stretch those out for their lifetime if they're disabled or if they have special needs of different types. Or they're underage, it can stretch out their distributions. But the old planning that I used to do of putting 401ks and IRAs into trusts just to stretch them out for anybody no longer exists. They did away with the ability to stretch those. But for certain beneficiaries, we put them in. It's generally kind of a more supplemental or special needs trust planning than anything at this point. So one thing I'll mention is there are ways in this trust to make your insurance overfunded and have some benefit going to a charity. There's a number of requirements that have to be dealt with in order to do that correctly. But that would be one area where you could do some charitable planning. If we're just talking about a charitable remainder trust, obviously the way that these work is you have basically donated your asset to charity, but retained the right to income for life. And there's specific rules about how much income you have to take, and the charity has to make. We have to make sure that the charity will get a remainder. There are very specific calculations for those. But where you would want to use those is if you've not gotten enough assets out of your estate, they're very, very useful for getting both a deduction for your donation to the charity and also getting a bunch of value out of your estate. So kind of back to this, if we're getting all the value out of your estate now with this asset protection trust or maybe the rental asset protection trust, if we've removed a bunch of value from the estate using these control and using these compliance mechanisms I've outlined, you may not even need a charitable remainder trust. You might just be able to do an outright distribution to charity out of your trust. They could be a beneficiary of your estate. Mm-hmm. Another area to give away money that's very tax efficient is through your 401k and IRA. Giving that money away as a qualified charitable distribution before you lay hands on it is a very effective way to give money. So I'd mention that as well. That's maybe one of the best things to leave. But if you, let's say you didn't want to give up control, you didn't want to do the completed gift, didn't want to do the compliance, didn't want to do this, and you just hung on to this in a trust where it's all in your estate, and there was an appreciation event between your rentals, between XRP, between all your assets, you had enough appreciation that the estate was taxable. Well, that would be where a charitable remainder trust would come in. You could donate those assets to a charity, retain income for life. And we can actually reform this trust to do that later. Or if you've already got too much value or a bunch of appreciated rentals, that's another good scenario. If these rentals were highly appreciated, we could actually form this rental trust to both be protective for assets, but also to retain those assets for your use during your life. But the main ways in which to give to charity, I would say, would be, first of all, let's get these assets out of your estate so you can have discretion over when to give to charity. If we haven't appreciated assets, though, then that would be a scenario where we would maybe want to set up a charitable remainder trust to get these assets over to a charity, because again, charities don't pay the appreciation tax, the capital gains tax. Once you've transferred it to them, there are some donation restrictions. When you transfer appreciated properties, you don't get quite as much deduction. And be aware that your remainder payments, there is capital gains tax to the extent your remainder payments have a pro rata portion of appreciation attributed to them. But the charitable remainder trusts are very effective where you have, number one, appreciated properties, and number two, too large of an estate. I set up a number of private foundations for clients, and we can set those up in different ways. I sometimes set them up often, as I mentioned, with these mortality wealth trusts, and we'd often set them up with donor advised funds. If you're just doing a simple family foundation that you don't need complete control over, If you need a private foundation for yourself, then yes, we can set those up. I've done a significant amount of structuring of those. They come with, again, a lot of tax compliance. So you have to be careful, make sure you know what you're getting into. But yeah, setting up private foundations is another way to give away money and get tax deductions. But just be aware that foundations do have to distribute. They've got a bunch of excise taxes applicable to private foundations. And so the donor advised funds haven't yet come under full private foundation law. There's, of course, a lot of congressional impetus and momentum toward that. But those currently, the donor advised funds are a pretty good kind of hybrid to retain some control while at the same time being able to get a charitable deduction. I pick the jurisdiction that is best for the asset. Now, if you were trying to put your rental properties in Georgia into a Wyoming trust, Georgia is going to have what's called quasi-in rem jurisdiction over those rentals. And under quasi-in rem jurisdiction, Georgia can say to you, if Georgia came to you, something happened with one of your renters over here, and the state of Georgia, the court system came to you and said, hey, somebody's suing you, you're going to have to pay. And you said, well, I've put that Georgia rental into a Wyoming trust. Georgia's going to say, whatever, that dirt is stuck here in Georgia. You're subject to Georgia laws. So you got to be cautious about the type of asset you put in. But for digital assets, because they don't have a specific situs necessarily, they're in the cyberspace, those are good assets for a Wyoming trust. Same thing with equities, same thing with businesses that are in interstate commerce. So you do want to pick the trust. If you were talking about Georgia rental properties, we would probably set up a Georgia asset protection trust for those properties. And that's why there's often multiple trusts, because we pick the jurisdiction best for the asset. Not all states allow asset protection trusts. And so I'd mention that if you're in a state that doesn't allow them, like around 20 states permit them. If you're in a state that doesn't permit asset protection trusts, we use different trusts that deal with powers of appointment. That's a very complex topic to get into. But I generally recommend that the real estate in a specific state only go into a trust that the particular state would recognize. So if you're in a state that does not recognize asset protection trusts, I wouldn't go dropping your real estate into an asset protection trust. I would drop it into a power of appointment trust, which is a kind of a workaround that permits some asset protection for assets. I wouldn't drop, for example, Idaho right next door to me doesn't permit asset protection trusts. So with digital assets, that would be different. There's most states, if the state doesn't have jurisdiction over the asset, then they're gonna afford full faith and credit to the state where the asset is sitused, and so that would work much more effectively. You always have the risk of a state court judge, but putting it in an asset protection trust is a big line of defense for you. Mortgages, again, are subject to state laws. So you have to look at what state that's in. It is a real estate interest. So we have to make sure that we're cautious. But any state that affords protection, and by the way, Georgia does have an asset protection trust statute. So they would likely afford protection to another state's asset protection trust statute. So it just depends on the state. That's where you've got to look very carefully at the transfers into the trust to make sure that the transfers into the trust are carefully considered.